fairness compared to communities that I represent, which were able to offer direct economic stimulus program, and those businesses that were eligible to apply for my local grant programs are also eligible to apply for the business interruption grant program. So they get 2 bites at the apple. You're limiting downstate communities to 1 bite at the apple. There seems to be an inequity there. I'd like to know that you actually have some, concrete basis in your legislative interpretation.
So, if I may, the statute says that financial support funds may be used by a unit of local government only for payment of costs that are necessary expenditures incurred due to the public health emergency of COVID. And the DCEO used the incurred necessary expenditures to focus on a program that would make sure that those dollars got to those communities that expended necessary expenditures. I understand what you're saying. It's not a prohibition against an economic support program. However, we interpreted the appropriation that DCO was given for $636 million to DIG to be that is the main economic development program, and this is devoted to make sure that local governments can address the expenditures that they incurred.
Well, I mean, with all due respect, the US Treasury Department defines expenses associated with the provision of economic support in connection with COVID-19 public health emergency, such as expenditures related to the provision of grants to small businesses to reimburse the cost of business interruption caused by required closures. Expenditures related to a state, territory, local government, or tribal government payroll support program, unemployment insurance costs. So the
Sure.
US Treasury allows it. You have taken a step to limit it. I would surmise you got that wrong. Your interpretation is just incorrect. It was not the legislature's intent to limit the CURE Act to not allow economic support programs through the expenditure of these funds for local communities.
Sure.
And you don't have, from what you read to me, that's not a limitation. That's a broad-based guidance in which number 5 in the US Treasury Department's guidance fits very nicely under. I'm going to move on, but I would ask you to please take another look at your interpretation on legislative intent. I don't think you have a good basis for that interpretation. And really, it creates an inequity here. And again, I don't represent these communities. My communities received direct funding, Cook County, DuPage, and Will County. But there's an inequity here. Okay, so here's my original. The remainder issue, or unspent funds issue, where you have this administrative November 1st guideline, or I guess you would call it a check-in date? Maybe?
Yes, that'd be the way to characterize it.
So when you say you're going to reallocate funds where they are most needed in the state, are you reallocating funds under the CURE Act?
Under the the local CURE program, yes.
Correct.
Yeah, so they'd still remain outside of the 5-county area.
So that would be geographically limited to reallocation within just
the same pool.
the same pool, the
Yes.
same
Yes,
eligible
sir.
communities within the CURE Act. Okay. The big program, you have a first round of I understand and I appreciate, I had a quick conversation this morning with someone from your department, so thank you for the communication. I understand that you have the first round of approvals completed, is that correct?
Yes, that's correct.
Do you know what the breakdown is in the first round of approvals between Cook County, Collier counties, and downstate businesses?
That's still being addressed right now because the application process ended, I believe, the end of last week, if not early this week. We're still going through those numbers to make that determination as into where it breaks down and where these businesses fall in terms of the disproportionately impacted areas.
Well, I would ask, and I appreciate that you just had a deadline. It takes time. If you could run a breakdown for the first round of approvals and forward it to the committee.
Okay, I can do
That would be helpful. You talked, you said you spoke with the interested parties that are opposing your emergency rule, specifically IML, counties. Well, actually, I haven't heard from the county association, so I'll set them aside. My understanding is the IML reached out to you April 2nd to start a dialogue. I'm not hearing from IML that they believe any substantive conversations have taken place. Could you describe what sort of communication you have had?
When we had very limited guidance from the US Treasury back on April 2nd. There was very little known about the program. We were just at the very early stages of learning that we could create a program to help reimburse local governments. We can create a program that can help create a business interruption grant program. And right away, we spoke with IML and the Illinois Association of Counties because we wanted to learn about what sort of model would be feasible. Us and Gambi, Governor's Office of Management and Budget, saw that when administering reimbursements to local governments, we had to have the due diligence process on the front end so that reimbursements were requested and then the vouchers are then received. And we had spoken with IML and the Illinois Association of Counties about this clearinghouse idea that we had, because there's lots of other special taxing districts in Illinois. Illinois has over 6,000 units of local government, and there's park districts, there's townships, there's fire protection districts, there's all these other districts that are going to need COVID-related reimbursements, and we needed to find a way to fold those local governments in. Otherwise, it would show up in people's property taxes later on as there becomes enormous budget holes. And so we originally asked, hey, would municipalities or counties be willing to be a clearinghouse for these other special taxing districts? We asked if that was a good idea. And both associations said, hey, it's actually a little administratively easier on us if we apply and we get assistance, and then they apply and they get assistance. And that's actually one of the main things that we got out of those conversations, along with a predominantly per capita distribution of the funds as well, which pointing to the per capita distribution was written in the substantive language.
And the per capita was that was something that was actually in the original CARES Act. Federal government, how Illinois' allocation was determined was based per capita, correct?
Yes, and the different versions of the frequently asked questions that came out, there was one key one that was released actually after special session that in a lot of cases there might be confusion about the guidance that was released on May 28th.
Well, April 13th was the original guidance.
Yes, sir. There was one that talked about the per capita distribution to like a 45% level to local governments. So I wasn't sure if that was the same.
So I would, and you're correct, on April 2nd, when IML wanted to start a dialogue, you had no guidance from the US Treasury Department. You just had a statute. However, guidance was released April 13th. We're here in mid-July now discussing an emergency rule without really a lot of input from local communities that are most affected by your rule, and the clock is ticking. And I see that as problematic, and I see that as time the state is burned on the front end, because I can tell you, City of Chicago got their program up and running a long time ago. Cook County, it was breathtaking to their credit with how quickly they got a business grant program up and running with under the CARES Act guideline. They were well ahead of DuPage County, which also got a program up and running. I can't tell you when Will County fit in there, but we're well behind. And I think we got a lot of catch up, and you have heightened sensitivity to the back end, and I don't fault you for that. I think November 1st is a little early, especially with the updated guidance that was released recently dealing with that December 30th cutoff, which gives clear a lot of wiggle room after December 30th in terms of when the dollars go out the door.
True.
So, you know, we got relief, and a lot of other bigger governments that are administering these programs have moved their back-end guidance or deadlines based upon that updated guidance. So we got the relief, necessary from the US Treasury Department. I think you need to take another look at that. I realize it's recent, but that should give you, in my opinion, more wiggle room on that November 1st date.
So in the rules that you have before you, it has the discretion for this issue. It says if the guidance is amended at a later date, that the department can extend the deadline. And we do anticipate accepting reimbursement requests up through January 31st of 2021 to address that updated guidance.
Yeah, the guidance that we have is that the program would have to close down on the federal side by March 31st. So we have a tentative date set to request that local governments get to us their final reimbursements on by January 31st.
Is that I'm taking too much time? Do you anticipate amending the rule to be more clear on that for local communities based upon this updated guidance that we've gotten from the US Treasury Department?
So what I can say is we like the discretion to check in at November 1st to see, is there a gap where you don't actually need this money? And there are many other communities that still need it. So it gives us that ability, but we certainly, if communities are telling us, look, we're going to have reimbursable expenses all the way through the end of the year, then we can address it that way.
I'd like to turn and instead of looking back, now let's look forward. Where are we going to go from here? Because I have to tell you, if I had to vote on your emergency rule today, I would vote to suspend. I think you have work to do. I think you understand the issues. They're narrow. I think it's doable, but I'm hoping the department, and in fact, I'm asking that the department is going to work on this and come back with an amended rule before our August meeting. You have interested stakeholders that want to work on this with you, that represent these affected communities, and they actually have a plan in place, and this limitation on local economic stimulus needs to go away in your rule. And you need to, in my opinion, and I'm just one vote, find a way to accomplish such a program. The reality is it's going to be up to these local municipalities, and you're not going to do this through park districts, and so it's going to, certainly when you testify thousands, I understand you have thousands of local government entities you're dealing with, but when you're talking about administering a loan program, you just have to pick one lane. It would make sense to pick the municipal entity. That limits it right there to 1,100 is all you're dealing with. The reality is those 1,100 municipalities would have to front any money, any grants. That is also going to be a further limiting factor that's going to narrow that pool substantially, because not every municipality is going to want to take on that liability. That comes with, we have to get it right. If we don't have to get it right, we're on the hook. And that's the local municipality. I think you need to give them an opportunity and give them that local choice. I don't think you're going to have 1,100 participants. I'm pretty certain of it. But you're going to have some participants that are going to get an opportunity to offer their businesses the same incentive or the same relief that the businesses in my district were offered. And that's fairness. One state, one Illinois. Hear that from your boss all the time. This rule is not one state, one Illinois. This rule is different and creates an inequity in this state between Cook and the Collar counties and downstate, and that needs to be addressed. So I'd like to hear if you have any plans you can lay before this committee on that you're going to address this.
I do have a comment about the timeline that you spoke of. So this appropriation for this program, we only had access to funds as of July 1st. And the plans that we have set in place will administer reimbursements starting August 1st. And so, further delays in rulemaking will actually reduce, it'll it'll slow down the pace at which we can administer reimbursements to local governments. And we got a clarification that adjustments to the emergency rules can be made at any time. So,
Correct, but this rule is going to be up for a vote in August. And if it's in the same form, I'm voting to suspend your rule. I just want to let you know that. I expect it to come back in a different form. There's no reason you can't go forward with your August 1st reimbursement period for governments for governmental related COVID expenses while you hammer out, and you have this can be done quickly, an economic stimulus portion of this program and lift that restriction. There's no reason you can't do that. So we shouldn't be hearing the word can't or there's a problem. You come back here and you can't make it happen. I would hope this committee holds you to a high threshold on the explanation as to why.
yes, dear, we'll definitely look at the rules again and resubmit.
Can I count on the department to work with IML and the other stakeholders
Absolutely,
on that amended emergency rule?
yes.
Well, we will certainly work prior to August with the stakeholders.
Will we see an amended emergency rule?
We haven't agreed to amend our rules, but we will certainly work with the stakeholders that you have referenced during the hearing.
Thank you, Senator. Representative Reich, you've asked for time to speak.
Thank you, Mr. Chairman. I'm still a little confused here. Okay, you've got municipalities able to determine their reimbursable expenses up to and including December 30th. And the November 1st date per you was done as a convenience, basically, so that you have the time to determine where excess money that is not being spent in particular locations is being reallocated to other municipalities. Is that correct?
Yes.
Did you convey that sentiment or that intent to the counties or to the municipalities, that this was not a hard date as far as submitting, but just an idea that we want to know where you are?
We certainly have, and I mean, we conveyed that it is it's a permissive item within it. There was no point that we communicated that the deadline was a hard deadline. The November 1 date has always been a May in the language, and if there was a miscommunication, it certainly was not at all intentional.
Well, I've got a letter here dated July 8th from the Illinois State Association of Counties where it says, IASCO's second concern is the restrictive window for reimbursements proposed within the emergency rules. The federal timetable allows governments to use CARES Act funds for costs from March 1st through December 30th, which you're granting here. That's fine. The proposed emergency rules allow for the initial reimbursement period from August 1 through November 1, after which unused funds would be reallocated based upon need. It sounds like, according to their interpretation of what they've been told, is that November 1st is not only the date that you need to have them reporting to you, is that this is the date that they're going to submit their reports, and therefore anything, they don't know what their costs or what their reimbursable things are going to be between November 1 and December 30th. According to what I'm reading here, they're interpreting your rule as saying November 1st is your drop dead date.
Ahead of the guidance that was updated on the 30th of June, it was the interpretation of Gombe that funds had to be completely out of the Illinois accounts before December 30th. And so originally, when the November 1st date was put in, it was in order to account for how to release the remainder of funds in time so the state does not lapse any dollars.
Well, it just sounds to me like you've created more confusion than you intended to with regard to the way that this is written, because, you know, the IML seems to be of the same opinion. That's what I'm reading from their guidance. I'm reading this letter from the counties. They all think that November 1 is a drop-dead date. So I guess somewhere along the line, there's either been a badly written rule or a sore lack of communication with the counties and municipalities who are subject to that rule. And like the senator said, if this was up for a vote on suspension today, I would vote to suspend the rules. And if there are no changes between now and next month's meeting, I will also vote to suspend the rules, because something's got to be done here. Now, I want to go over to the big program for a moment. Big applies statewide. Is that what you're saying? It applies to not only the 97 counties that did not receive direct federal funding, but it also applies to the 5 counties that did. Is that, am I hearing that correctly, or am I wrong?
There are both appropriations statewide and appropriations that are excluding the 5 color counties,
All within the big program?
all within the big program, yes.
Okay. So are you saying that the Cook, DuPage, Lake, Will, whatever, all got economic development funds? Were those economic development funds through what you characterize as the statewide portion of BIG?
The statewide portion of BIG is just the current appropriations that we have. The funds that Cook County and the other counties that receive direct allotments, those are direct allotments from CRF.
Okay, so it does sound like the 5 counties, the Collars and Cook, are getting a second bite of the big apple that should have been, in my simple interpretation, should have been left strictly to the 97 counties who did not share in the direct federal program. I don't see how it is that BIG is made up of 2 components, and how are you going to maintain the separation between the statewide component and the 97 counties who weren't part of the direct federal thing with regard to allocation of big funds? How are you going to do that?
So through the certification process that we've set up, one of the big components is that you can't have received funds from the federal government and also receive funds for the same issue through the big program. So through our due process and due diligence, we are looking at those applications to make sure that if they've received funds for this particular situation, that they can't, that they're disallowed from being able to collect funds through this big program, if that answers your question.
Color me skeptical. I guess my point is that, let me ask you a question. If we have Cure Act money left over, just haven't spent it all. I mean, you can't allocate it out to the other counties or municipalities or whoever. We've got a chunk of money still sitting there as of December 31st out of those Cure counties. Is there a possibility that that money could get transferred over to the 97 county version of the Big Act and be allocated out for economic development?
No,
Why?
because those funds were allocated for a particular program. We more or less would need legislation to be able to allow those funds to be then reappropriated to a different set of funds.
So, okay, all right, I'm not going to follow that. I do believe that what you're doing here is sort of putting our I'll tell you frankly, my county is the largest county that is under 500,000 in the state, okay? So I've got an interest here. instead of allowing or telling McHenry County that it has to have a November 1st deadline for submitting to you the anticipated costs, because again, we got a whole bunch of people and we don't know what those costs are going to be. Wouldn't it be better if that November 1st deadline was something that the counties themselves could opt into if they don't have the resources to do the grant writing or the audit staff to do the kind of stuff that, you know, needs to be done with regard to this, this reporting? And leave a county like McHenry, which has got a pretty robust reporting, you know, grant writing and audit function and staff, giving them the flexibility to do something just the same as the larger counties have been able to do, where they don't have to make that kind of a determination. November 1st is coming upon us real fast, and I'll be honest with you, personally, I think we're going to see a reflush of this pandemic, and I believe that what we're going to see are accelerating costs going into the fall. I think that you having a November 1st date and then starting to make your plans to reallocate out to other counties is being very, very optimistic about the fact that this thing is fading into the, you know, in the rearview mirror. I just don't see it happening. I want to just stress the fact that, you know, hey, you got a hard job here, man. It's sort of chicken and egg type of thing, really. But at the same time, I do believe that these rules need to be tightened up. They need to be recommunicated to the stakeholders in a way that, you know, you're working with us, instead of having the impression being that this is a drop dead date, take it or leave it. Because that's the kind of, I get phone calls from my county government, I get phone calls from my municipalities, and now I've got this letter from the Association of Counties that think that, you know, I've got to get this thing done by November 1st, or I'm not getting anything else out of this. And that's just not the way that I think you want to do it, and I don't think it's the way that it should be done, and I think that rules need to be reflective of that.
We appreciate the ability to clarify the November 1st issue, and even though it says may in the rules, but perhaps this discussion will help those associations and help our discussions with the stakeholders before your August meeting.
So you will commit between now and then to talk to IML, IMA, IRMA, counties, and let's all come to the table. Let's come to this meeting next August or next month and have an agreed set of rules that everybody can live with. That's what I'm hearing from you as a commitment.
We'll certainly have that dialogue, absolutely.
Thank you.
And I just want to add, and we're talking about exactly letting these counties being able to set up these programs and the various issues as to why we have not done that. And I want to say that the overarching concern, or at least one of our major concerns, is making sure that the funds that are dispersed, we are not at a later date having to deal with the fact that those funds are now being disallowed and that the state is now on the hook to have to repay those. So when you mention 1,100 municipalities, which may not opt into this particular situation, that's 1,100 is still a lot for DCEO in and of itself to have to police and make sure that they are operating within the parameters that are set up by the Treasury, and understanding the fact that the Treasury has not given enough guidance so that we're certain that we won't have to deal with them at a later date in a different situation. So just want to point that out there overall. But we will continue to have those conversations, both with IML and all of the necessary stakeholders.
Thank you. John, you want to respond very quickly, please?
I think the important point that I'm not hearing from you is an understanding that it's the municipalities that decide to undertake an economic stimulus program. It's their dollars that are going to be on the hook. Because if you, in vetting any reimbursement request from their program, don't approve it, that municipality is on the hook for those dollars. They've already expended it to that business. So it's not the state's liability, it is the municipality's liability, and that in and of itself is why they're going to be very careful in proceeding forward with any economic stimulus, but it gives them an opportunity, which is fair, and quite frankly, I think is all we can ask. Thank you.
Thank you. And members, just so you're aware, more than half the committee is asked to speak yet again. So we're going to have to move things along a little bit here, but I want to make sure we get to everybody. Senator Cunningham, if you'd like to go next.
I just wanted to add a couple things really quickly. I think you've heard that there's a feeling among the committee members, and this is a bipartisan feeling, I think I can say, that this needs work. And we're gratified to hear that you are committed to working with IML and other stakeholders on this. Another thing I would urge you to do is work with the JCAR staff. There's been a lot of back and forth about this November deadline and the word may being attached. When you put the concept of a deadline, but then add the word may to it, that's an inherent contradiction. And that's going to create a lot of confusion. So I want to urge you to work with the JCAR staff on drafting an amendment to this rule. And I think that if we can clarify some of those things, it's going to make it a lot easier to reach an agreement on some of the bigger themes.
Thank you.
That's all I have.
Understood.
Representative Halpin, please go ahead.
Thank you, Chairman. Again, I want to go back to the beginning a little bit, but when it comes to treating the 5 counties and the city of Chicago, or 4 counties and the city of Chicago differently, that wasn't a choice that DCEO necessarily made, correct?
Correct.
All right. So the federal law gave that money directly and had federal strings attached, whatever they were, correct?
Correct.
And obviously what you're working with is what we in the General Assembly gave you to work with, which is several different funds for, IEMA, and then we've got the big program with you, we've got
Correct.
the local government fund with you. So I guess, is it fair to say if we had just delivered these programs and they were all statewide and the federal government didn't give anything directly, is this the type of program you would have come up with for the whole state? I mean, I don't want you to necessarily speculate, but this was your best effort, correct?
It was, and I think as the Economic Development Organization for the state of Illinois, we would have put together a grant program to assist businesses, and that would have been in our scope altogether. And when we're called on to run a local government assistance program, we're here to do that as well.
And more specifically, when it came to the big program, you were given legislation that said at least a third had to be from downstate, right?
Yes.
And if that big grant came through and said 2/3 of it had to be downstate, you would have administered it that way, right?
Yes.
And I for one, I want to say that during the budget process, I argued for a bigger allocation to downstate for these big funds. I wanted more money to come to downstate for that very reason, that 5 of our counties in the city of Chicago already got money that could be used for economic development and reimbursement in that way. But the problem is I lost. I didn't get that in the final budget. But I did get this millions of dollars for local government reimbursement because I know my communities were hit pretty hard.
If I may have
Sure.
one thing to note is that in the language for the big program, it does focus on disproportionately impacted areas. So if you have a disproportionately impacted area, we've posted a map on the DCO's website, and many of them may be in your districts, and those get special preference on funds for the Business Interruption Grant Program, and also through our Allotment C on the Local Cure Program. We are helping local governments that didn't get a set allocation for Local Cure through an application process, and we're helping and making sure that the ones that are in the disproportionately impacted areas get assisted first.
Right, and those could be airport districts, other very specialized districts that may
Special
actually
taxing
have
districts,
COVID-related expenses. Okay. I do want to echo what some folks have said about the the deadline issue. I understand that the goal that you're trying to get, having it be a permissive reallocation, with the idea that some of our towns may not have expenses that meet their allotment. And I think that money should go to other communities that have had to spend more on COVID-related expenses. And I'm going to disagree with some of my colleagues. I represent a downstate community, but at the same time, all downstate communities aren't the same. And in fact, for the past several months, I've been told very regularly by some people, my colleagues representing downstate areas, that their area hasn't been hit that hard. And they don't want to follow the rules, and they don't want to wear masks, and they don't want to socially distance. And I think that allowing some of those communities to have money above and beyond what their actual local government costs were, to the detriment of potentially my county and my municipalities in my county and my district, is unfair itself, especially given my location on the Iowa border, where we're seeing cases increases. And the other problem I have with it is that I believe Senator Kern is right, that municipalities, if they want to do some of this business economic development programs, they are going to have to spend that money up front, which means that the communities that are wealthy and can afford those type of grants are going to be able to use that money to do that, while the poorer communities aren't going to be able to offer that same kind of assistance. I think it's much better off if DCEO is running that on a statewide basis that can actually see which specific municipality needs that money for business expenses, and so that those municipalities can actually get the business assistance. So I you know, as it stands now, I think you do have some work on the timeline issue, but overall, I think it is a fair way, given the way our hands were tied by the federal government. I think it is a fair way to try to get some of this money to the local governments that need it. So just my 2 cents. I appreciate the time, Mr. Chairman.
Yeah, thank you, Representative. Senator Resin for a follow-up.
Again, to follow through, that you're going to have a discussion with the parties that have raised concerns. And the 2 areas we're talking about are the timeframe. So the November 1st permissive timeframe, potentially giving these communities more time. And then also working on adding back in economic support to the language for reimbursable expenses. Is that correct? When you have a discussion, I just want to make sure that it's a productive discussion.
Absolutely.
That's what we hope to see in a month. That's what I hope to see.
Yeah, we definitely will have a conversation on both of those topics, and so we could air that out with them. Exactly.
With an agreement. Thank you.
Thank you, Senator. Representative Petty.
Thank you, Mr. Chairman. Just as a matter of clarification, where do we stand as far as status? Because what I think that I heard is that the committee is prepared to allow the emergency to proceed until the next meeting, but for you to come back with some definitive answers to several questions and maybe even a re-strategy of how you want to implement this. I believe that I heard the CFO indicate that there would be amended rules filed, but then I think that I heard the General Counsel say that she was not so fast to commit to that. So where do we stand now for the next 30 days?
Sure, and it might be helpful just to give you context of what DCO is working on right now and why the emergency rules are so important to us. So we are selecting.
Is your microphone on?
It is.
It
Can you
is,
hear me?
okay.
Sorry.
No, it's
It's
okay.
new to me to talk in with a mask. Okay. So DCO is selecting a third-party administrator right now, and the third-party administrator will be very helpful to the department to make sure that we process the reimbursement requests in an efficient manner. So that is happening while we speak. And then the next piece is that we are in the application allotment for allotment C that you see in the rules. So those other units of taxing districts, the special taxing districts, are applying right now. It expires on July 17th. And so all of these things are happening right now because our department is so focused on making sure that the money gets in the hands of the local governments. So if this process were to stop during July, it would further delay things. That is the first piece. So yes, we will come back to you in 30 days in August and provide an update on our dialogue with those associations and stakeholders that have been referenced during the hearing. Regarding an amendment, I just don't know without speaking with any leadership at DCEO what amendments we could entertain. But certainly the deadline, I think it sounds like further clarification and amendment is needed. And so I think at a minimum, we can acknowledge that amendment is necessary.
Understood. I just
Okay.
want to make sure that we're all on the same page when we come back in 30 days. I do know that Mr. Cole is here. I see him, so that at least you can check that off the box and having a meaningful conversation with Mr. Cole when we leave. But again, perhaps maybe, I don't know who was serving as the scrivener during this hearing, but do you think that we can recap what the issues are, that you'll go back to leadership and see whether or not they can be incorporated in the amendatory language? Can we do that now, just so that members can hear what you intend to work on and what you intend to run to the corner offices, so that we can make sure that we're all on the same page?
Yeah.
The two main issues that I heard is the deadline issue, the November 1st deadline, to clarify that is optional and permissive. The second issue is that DCO will have a dialogue with the stakeholders about their request for an economic development program with units of local government, right? Those are the two main issues.
Were there any other issues, Mr. Chairman? Overriding issues? All right. Thank you very much.
Thank you. I'll add a couple quick questions here at the end. And thank you for your indulgence, your patience in answering the questions. But one of the things that came up in my discussions with stakeholders has to do with, we're talking about how we potentially apply this business economic reimbursement to the local municipalities are interested in. And some of them brought up facts that some categories of businesses are not allowed under the big program. And you're thinking of, because there's, headcount requirements or income requirements and limitations that are in there. I think that what we're saying perhaps is the big program might need to be adjusted to allow for some of those, if we can't find a way through how you're reading the statute to do what we're asking you to do right now as a group. So I want to make sure we're thinking the bigger picture here of how we actually solve the problem we're trying to solve. I think that the path laid out for what's being presented by my colleagues still has plenty of merit and should be explored at all opportunity, but at the same time, let's look at the whole picture as well. So can you, is that something you could look at as a?
Yeah, so
entity?
we can look at the businesses that are not allowed under the big program. I guess my question is, what businesses have you heard are not allowed to participate under the program?
So if you're looking at like event spaces, banquet halls, businesses that don't have a high head count, don't have, the income range that is going to be allowed under big. I actually ask you a question about big altogether.
Okay.
We're working very hard right now to ascertain that rules for the CURE program are going to be in place in the appropriate time frame.
Right.
Are there rules for the big program?
Yes. We are.
Where are they?
So our intentions are to file them this afternoon. However, we are still working through some issues with stakeholders and other agencies to make sure that we address everything that we feel is necessary.
Did I hear it said earlier that you're already taking applications for the big program now?
So there's a round one that's been placed, that's been set up under the big program, but there's a larger round that will take place later on after these rules have been filed.
So we're actually operating in policy outside of rule currently then?
So we've taken applications, but money has not been dispersed, and because we want rules to be filed before we disperse money, we will not disperse money until these rules are on file.
How would I know as a business owner to have been applied for this, what's this round one that you're referring to?
So that information has been placed on our website, has been announced through other particular groups as well. But for round one, it's also limited to only restaurants, bars, areas in...
Is round one defined in the statute?
No, round one is not defined.
So that's a DCO policy choice that's being implemented right now with no rulemaking to support it.
Right. So rulemaking is not mandatory because we already have enabling legislation. However, because we want,
You said you have enabling legislation for a program,
right,
but you've made policy choices within the program that aren't delineated by rule, which is part of the IAPA, which you're required to follow. That's why
Right.
this whole committee exists.
with that being said, that's the reason why money has not been dispersed, because we want rules filed first. However, we have taken applications, at least for that round one, which is a much smaller program. And as in, whereas the round two would be, have a larger dollar amount and would be dispersed for a larger audience.
Okay, well, I'm going to hold my questions any further on that bid program because I think that the department's out of line in the process that they've taken here. Okay, that's my opinion, and I think you've answered the questions that support that. I'm going to return back to the CURE program here and echo the comments of many of my colleagues.
Okay.
I don't think this rule is done. And if you want my direct opinion, if you can't change the deadline and make that clear, Victor, there's no deadline right now. The way I understand what you put forth, you have a November 1st check-in date, but there is no deadline then, right? So I could come back in the end of 2021 and say, hey, by the way, here's my municipality's bills for COVID, reimburse me. Because you put nothing in the rule that says that it has to be done by then, right? That there's a 12/31 or a check-in date's not the same as a deadline.
Right.
So something has to change in this rule.
So that is in the rules under, let's see, 700.5, 50 restrictions on use of program funds. It has a limitation that said were incurred during the period beginning March 1st, 2020, ends December 30th, 2020.
You also told me that that expenses through 1/31 of #21 would be acceptable
So
in
that-
testimony.
No, we said on an accrual basis, costs through December 30th, but you can't feasibly request for a reimbursement for something on the very same day it happened. So if someone purchased PPE on the 30th of December, we are looking to receive those reimbursements over the next month because we have 90 days to close out the program.
Okay, so I've been listening here for, what, an hour and a half of discussion about one small section of one rule, and I'm getting it wrong after listening to this and reading all the documents that have been sent. This rule has to be changed. If it's not changed by next month, I'm pretty sure that there'll be an action taken, or at least a motion made, by this body. So please, work with your stakeholders, work with JCAR staff. We actually all want to see this actually happen in a timely fashion that supports our communities. We're not against you, we just want to get the rule right.
Yes, sir.
So with that, any other further discussion on this particular topic? Okay, we're going to finish up the meeting real quick. If you wouldn't mind hanging around for just a minute for a couple of follow-up things we can do after the meeting, I'd be grateful. Thank you so much.
Thanks for watching, and if you haven't already, please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.